Hello and welcome everyone to our first Fenwick Elliott webinar of 2022. I think I'm just still within time to say Happy New Year, and I hope you had a lovely holiday at some point. After our short break over the December holidays, it's fantastic to be back here with everyone today. Thank you very much for joining. My name is Stacey Sinclair, and to kick off our 2022 series, we are of course focusing today on PFI disputes and PFI contracts with a case law update. A very fascinating and at times a rather complex area of law. And thankfully, to take us through this area, today I'm delighted to introduce our two speakers. Firstly, we have Fenwick Elliott's partner, Ted Lowery. Ted is a specialist in PFI contracts and dispute resolution on PFI projects, in addition to his expertise in construction law. And also a very warm welcome to Barrister Fiona Parkin, QC, of Atkin Chambers. Fiona also specializes in PFI contracts and dispute resolution, having been involved in a number of very high-profile cases. Fiona is a leading silk in this area, and in addition to her this practice, also specializing in professional negligence and construction and energy law. Thank you both for being here today. But before I hand over to our speakers, just a few points on admin. As usual, please do put your questions into the question box, which you should be able to find on the right-hand side of your screen in the toolbar. Do ask questions as we go, and we should be able to put a couple of them to our speakers anonymously at the end of the session. And one of the questions that we always do get is absolutely the slides that you'll see in a moment, as well as a recording, an on-demand recording, will be available on our website, and I will make sure to put a link also in the questions box where you can find those slides and recording. So without further delay, Ted, I shall hand over to you. Let me get the slides.
Thank you, Stacey, and welcome to everyone. We've never done a webinar or indeed a seminar on PFI contracts, so I thought it'd be a good time to make good that omission. I'm very grateful to Fiona for volunteering to help in this presentation and provide her expertise and insight into what Stacey has said is a fascinating subject. Today's agenda is on screen, and after this brief introduction, we're going to look at 4 recent judgments on PFI contracts. There's not been a lot of judgments in the courts on PFI contracts, so having 4 cases in 2 years is something of a deluge. The reason for that is most PFI contracts provide for adjudication arbitration, but the courts have had a look at PFI contracts in these 4 judgments, so we're going to look at these. I'm going to talk about Serco and Fork Health, and then Fiona will talk about Essex County Council and EBB. I will talk about Surrey County Council and Suez. Fiona will talk about Buckinghamshire County Council and FCC Buckingham. We'll then have a summary where we'll try and draw a few principles together, and then hopefully time for some questions. Well, there will be some time for questions at the end. So, right, I don't imagine that a webinar on PFI contracts is going to attach the the casual observer. So I'm hoping and imagining that everyone participating today has some familiarity with the nature of PFI contracts, how they're supposed to work, and their structure. However, to put the 4 judgments we're going to look at in proper context, I thought it was worthwhile just setting out some of the typical features of PFI contracts, and they're listed there on the slide. Firstly, they're relational in nature. That means they're based upon relationships of trust and confidence between the parties. Secondly, they're long running, and this is a key feature of them, that you typically have 2 years for construction and 25 to 30 years for servicing the new building asset thereafter. Thirdly, they are complex and extensive provisions, and they normally take the form of a series of interlocking and interrelated contracts, at the centre of which is the project agreement between the project company and the local authority who is looking for a new hospital or school or prison or police station, whatever. And then the sort of main subcontracts are with the building contractor, between Project Co and the building contractor, and with the FM contractor, who provides the services over the services period once the building is complete. Fourthly, they're often very high value, something that attracts a lot of attention in the press, I think, but they are valuable and profitable contracts, and a lot of money changes hands. And fifthly, and this perhaps is the reason why we're talking today, because of the complexity and length, they are susceptible to interpretive arguments, quite significantly so. And anyone who's been involved in a PFI dispute will recognise that some of the key provisions are not often very clearly expressed, and that leads to arguments over what the contract actually means. And I've set out there a comment by Lord Justice Jackson in Amy Birmingham Highways Limited and Birmingham City Council, which I think is very insightful. In that case, Amy tried to argue that the project agreement they had with the council for working on the roads did not extend to all of the roads in Birmingham, but just some of them. The court did not agree and found in favour of the council, saying that in the proper interpretation, they should be tarmacking every area, not just half of it. But the line of argument adopted by Amy in that case did lead to Lord Justice Jackson making this observation in his closing comments on his judgment in the Court of Appeal. So he says there, any relational contract of this character is likely to be of massive length, containing many infelicities and oddities, and therefore a reasonable approach is required. And it's that insight that we have borrowed for the title of this talk. Now, the four cases we're going to look at, judgments we're going to look at, all sort of centre on what we may broadly call infelicities of one kind or another, or oddities or omissions. And I think in that, to that extent, in my experience, they're fairly typical of the disputes that I certainly have a lot of involvement in. I'm sure Fiona is the same. Essentially, what do these contracts mean, and how does one interpret them sensibly and properly? So I'm now going to go on to the first case, which is Serco Limited and Force Health Limited from 2020. It's a Scottish case. The project agreement concerned a brand new hospital at Falkirk. The parties, Serco Limited, were the FM contractor. They were the ones providing the services, and Force Health Limited were the project company, party with the project agreement with the local health authority. As I said, it was a brand new hospital in Falkirk, and the hospital was completed in 2011. And thereafter, Serco began providing services. Now, in 2020, a problem arose as to the meaning of a term in the contract that was undefined. That term was the first market test date. Ultimately, the claim for, Project Co wanted the claim summarily dismissed. The court thought otherwise, and I'm just going to explain why. So if we look at the key contract terms in Serco and Force, I'll set them out there. The first one is the formula that is used to calculate the annual service payments due to Serco under the Facilities Management Agreement. Now, as you can see, it's a fairly detailed and complex calculation, and this is very typical of the manner in which the service payment is worked out under FM agreements and indeed in the project agreement. The issue here concerns the value Z. And now if you look at the calculation, there's a quadratic in brackets. The second one from the right at the end includes the figure Z. Unfortunately on the slide, Z is slightly obscured, but paragraph 2.1.7 in the Schedule B, Section B of Schedule 18 for Facilities Management Agreement defined Z as follows. For the period until the first market test date would have the meaning in paragraph 2.1.6, but for the period after the first market test date, it would be nil. Now, that part of the equation there was intended to provide some compensation to Serco in the event of wage increases. And the idea was that Z represented, as it says there, a formula. But that formula would become redundant, formula, sorry, for calculating wage increases. So that would become redundant after the first market test date. It would reduce to 0. And the idea was that the first market test would take over, and that would, once the market test was done, that would accommodate any rises in wages that were fairly due to Serco. Now, the problem was that if we look at the definition of what Z is, it says for the period until the first market test date. That's a capitalized term, which suggests that it is a defined term. Now, in fact, it wasn't a defined term. The FM agreement included nothing that looked like a market test date definition. So what did it actually mean? Well, Project Co looked at the definition of the market testing date, which is set up at the bottom of the slide from part 17 of the schedule. This said, well, the market testing date is every 7th anniversary of the actual completion date during the project term. Okay, it's obvious, isn't it? If the hospital was completed in 2011, then the first market test date is 7 years after then, so it's 2018. That's your first market test date, because that's the date when the first market test can occur. Surely that must be right. And on that basis, they suggested that Serco's claim should be summarily dismissed. Now, in fact, the judge decided otherwise, and the reasons why he did so was that. Sorry. Yeah, sorry. Serco said that the fact that it wasn't actually defined meant that, just that, it wasn't defined, and therefore you couldn't actually tie it to any other definitions in the FM agreement. You had to simply give the words their normal and ordinary meaning, and they said their normal and ordinary meaning of first market test date on an uncapitalized basis was the date of the first market test. Now, the market test hadn't occurred in 2020. It could have taken place in 2018, but had not. And they said it was actually logical, therefore, that the first market test date was the date the first market test occurred, and if that hadn't occurred, then Z could continue to be as defined in paragraph 2.17a and did not revert to nil, i.e., they still got wage protection or protection against the wage and salary increases until the first market test. Now, the judge agreed with Serco and basically said that it's he described the Serco's argument as being not bound to fail. And on that basis, it was not necessary to summarily dismiss it. So judgment was given to Serco, but we don't know what happened after that, I'm afraid. I assume that what happened is that they, Serco and Project Co, reached an agreement to settle the dispute. But I think there's two things there in terms of this dispute which are quite common. The first one is that most project agreements, or sorry, PFI contracts, will include terms that are capitalized but are not defined, and equally include terms that are defined but not capitalized. You've got to try and work out which one is which. Also, similarly, you will find certain important documents like the schedule of program maintenance, for example, often referred to by different words and phrases in the contract. So again, you've got to work that out. And I think the second typical occurrence on this case is that the problem arose because something happened. Something didn't happen that should have happened. Had the market test been carried out on the 7th anniversary of the actual completion date, then the issue would not have arisen. It would simply been, okay, we've had a market test. The market test has accommodated Serco's position on wage increases. Therefore, we're happy to accept that from this date, the value of Z is nil. That hadn't happened. For whatever reason, the parties had not undertaken a market test as anticipated. And this gave rise to a problem which amounted to what was one of the infelicities that Lord Justice Jackson referred to. What does first market test date mean when it's not defined in the contract? And I think that is a fairly typical example of the sort of issues that arise on PFI contracts. It's very similar to several issues I have at the moment I'm working on. What does a capitalized term that's not defined actually mean? So I think that's informative. I'm now going to hand over to Fiona to talk about the next case, which is Essex and meeting B. Fiona, thank you.
Thank you, Ted. In contrast to Serco, Essex County Council is a decision following a full trial of whether or not Essex had the right to terminate a long-term PFI contract as a result of UBB's failure to achieve or pass acceptance testing of an MBT waste treatment facility. And the failure to pass the acceptance testing meant that the project never moved into the service period. Essentially, what's important about this case is the way in which the judge summarises and considers the good faith duty, how it applies to PFI contracts, and in particular, how it applies to the facts of this case. As we've set out there on the slide that you can see on the screen, the judge concluded that this was a relational contract, and as such, the duty of good faith would be implied into it. That's perhaps not very much of a surprise for any of us who do lots of PFI work. As Ted said at the beginning, a hallmark of a PFI contract is that it is relational. What's more interesting is the way in which the judge, having identified that this contract was subject to a duty, an implied duty of good faith, went on to consider the way in which that duty might assist or otherwise UBB from extricating itself from the difficulties in which it found itself. And just before we come to look at that, it's perhaps worth setting out precisely how UBB found itself in the position that it did. The judge described this essentially as a project in which UBB approached the design of the facility in an extraordinarily cavalier fashion. They designed waste treatment halls which were half the size actually needed in order to discharge their performance guarantees. And fairly early on into the project, they realised that, in fact, they had fundamentally misdesigned the treatment halls and the process itself. And so they needed to work out how the hell they might overcome those design deficiencies. Importantly, they did not tell Essex County Council quite how fundamental their design deficiencies were, and they kept them very much in the dark. What happened was that Essex was drip-fed the potential solutions arrived at by UBB as to how they were going to overcome this design deficiency. And what UBB did was effectively, it designed a bolt-on treatment facility and then sought Essex's approval under the terms of the PFI contract to build and operate that additional facility. Essex went some of the way towards giving the approvals necessary, but stopped short of giving approval in relation to moving walkways, which would have allowed the two separate streams of treatment facilities to connect with each other. And the result of that stopping short of allowing the connection was that UBB was simply unable to meet the requirements of the acceptance tests. The argument that UBB effectively advanced was that, having given me some form of approval to carry out my modifications, you, Essex, were under a duty of good faith, to go the whole hog and approve all of the modifications I proposed, so that I, as Project Co, can construct facilities which would allow me to pass the acceptance tests and for the project then to move into the service phase. That argument did not assist UBB at all. The judge in Essex was extremely taken with the fact that the real problem that UBB faced was that it had been negligent in its design of the system from the outset, and that effectively what it was trying to do was use the implied duty of good faith to rescue itself from its own failings. And those failings had been compounded by its inability to be upfront with the council about why UBB found itself in the position in which it did. Having concluded that there was an implied duty, that the council was under an implied duty of good faith when it came to operating the PFI agreement and indeed in its dealings with UBB, the judge found that that implied duty did not extend to essentially allowing the contractor to undertake a slightly modified acceptance testing regime. The council was entitled to stick to the contractual acceptance testing regime which it itself specified. It said that the judge said that the duty of implied good faith did not allow the contractor to escape from the risks that he himself has assumed under the PFI contract. And also, and really importantly, once the contractor tried to start to renegotiate the terms on which it would carry out the acceptance testing, the judge said that the duty of good faith did not require participants to a PFI contract to participate in such renegotiations, and in particular to participate where those renegotiations meant that there would be a move away from the key contractual standards and obligations that the PFI contract had imposed on the contractor. And just standing back from the PFI contract itself, one can see why, in the context of public procurement, that was obviously the right conclusion, because one can't go around effectively changing the terms upon which UBB agreed to provide its services, because to do so would put the council in some significant risk of being in breach of its public procurement obligations. So essentially, having reached or set out that these were contracts to which duties of good faith attached, which, as I say, comes as nothing of a surprise to those of us who deal with these sorts of contracts. The judge, really, when one goes through the judgment, what one appreciates is actually just how difficult it is for either party to actually utilize a breach of that duty in order to support a position in which they find themselves. And that will be particularly so where the reason that the party is praying in aid an alleged breach of duty of good faith is down to its own default in the performance of its obligations under the contract. So although on the one hand Essex County Council is important because finally there is express authority out there for the proposition that PFI contracts are indeed the sorts of contracts where an implied duty of good faith will attach. Quite how far it takes any of the participants in those contracts is yet to be seen. So Ted, with that, over to you.
Thank you. Thanks, Fiona. Right, the second one I'm going to talk about is Surrey County Council and Sewers Recycling and Recovery Surrey Limited. This was a project agreement between council and Sewers as the project company. It was made in 1999, and the idea was that Sewers would construct 2 mass burn waste to energy facilities in Surrey somewhere. I can't remember where it was, but anyway, they couldn't get planning for this, rather oddly, even though it was the county council's own design. So rather than bring the contract to an end, Surrey and Sewers decided to try and make something of it. So they decided to, as an alternative, do something else. And what they did was between 2006 and 2010, they entered into a series of deeds of variation to the waste disposal project agreement, the aim of which was to provide for the construction of an eco park at Sunbury-upon-Thames. Now, the eco park was started, but problems arose and there were delays, and various problems, including disputes over the interpretation of the performance acceptance criteria connected with the manner in which the waste was disposed of. So in 2021, Surrey commenced court proceedings. They were seeking a number of declarations about how the contract should be interpreted, and they also, having lost patience entirely, wanted a declaration they were entitled under the Waste Disposal Project Agreement to issue a notice of termination. Now, all PFI contracts will have termination provisions in them, depending on certain circumstances, and they sort of lost their patience with their contract and want to get rid of them. Having commenced those proceedings, however, Suez responded and said, no, it's not court proceedings, it's arbitration. And therefore, they issued an application under Section 9 of the Arbitration Act asking that the court proceedings be stayed to arbitration. Now, the problem arose because of the differences between the deeds of variation and the original Waste Disposal Project Agreement. So I set out some of the key clauses there. The first two, 52.1 and 63 from the Waste Disposal Project Agreement, provide for expert procedure, which is called 51.1, which is not shown. But that was expert procedure in certain specific circumstances, where the expert would be an accountant or an engineer. Failing that, it was going to be arbitration. And then clause 63 contained the usual clause that the courts of England would have exclusive jurisdiction. That's fairly typical as well. Now, what happened with the deeds of variation was, as I said, there were 3 of them, and they contained similar terms. And these were deeds of variation created in connection with the construction of the Eco Park. So, clause 15.2 in the first deed of variation gave the courts exclusive jurisdiction in relation to any claim, dispute, or difference concerning this deed. And then clauses 13.2 in the second deed and 15.2 in the third deed used the language set out there, which again referred to court proceedings. So Surrey's point was that, well, this dispute concerns the Eco Park, therefore we should be entitled to go to court. And Suez said, actually, no, the arbitration clause in the original Waste Disposal Project Agreement still provides for arbitration. I just noticed there actually that the quotation from clause 52.1 does not specifically refer to arbitration, but that's what it actually provides for, so apologies for that. So what we're looking at is a sort of a clear conflict on the face of these documents, and the judge was asked to resolve it. And what he did, he nevertheless found a way through and decided in favour of Suez, that it was an arbitration provision that prevailed, and that was largely on 5 main grounds. The first one was that he took the view that the deeds of variation were consistent with the parties' continuing relationship. You know, they were ancillary documents to the Waste Disposal Project Agreement, and therefore part of it. So on that basis, he thought they're not like a termination agreement, which is going to be something entirely different, or indeed possibly a settlement agreement. They're still part of the original project agreement. So he decided that the Waste Disposal Project Agreement was in effect the master document, and the deeds of variation were the sort of subsidiary servant documents. And therefore, looking at things as a whole, he said it was more than likely that the parties would have intended that the dispute resolution process in the Waste Disposal Project Agreement would have been the provision that would apply come disputes, i.e. arbitration. The second reason was that he bore in mind that the courts of England normally construe arbitration clauses widely, and clause 52.1 did refer to disputes arising out of or in connection with the Waste Disposal Project Agreement, so he found that was a pretty wide definition. And also he bore in mind that the deeds of variation did not purport to make any changes to clause 52.1 or indeed clause 63 in the Waste Disposal Project Agreement, so these were preserved. And he thought on that basis, giving the clause for arbitration a wide interpretation, that was wide enough to capture any dispute over the Eco Park. The third reason was that the judge recognised the sense in providing for a common dispute resolution forum for all issues arising in the contract. He thought it would not be sensible if what you might call residual issues under the waste disposal project agreement would go to arbitration, but anything with deeds of variation would go to court. And he thought that it was not sensible or correct, that that would have been the outcome the parties intended. The fourth reason is that he thought that, bearing in mind that Surrey were trying to terminate the waste disposal project agreement, not the deeds of variation, were trying to terminate the whole thing and the whole thing to an end, it would be rather odd if any issues over the termination were to be decided using a dispute resolution process that appeared in the deeds and not in the original waste disposal project agreement. So, and again, another reason for deciding that arbitration should apply. And the sort of fifth reason is, I think, the judge just tying up a loose end regarding what might be said for the clear meaning of clauses 15.2 and 13.2 in the deeds of variation. So his approach to that was to say that the courts of England had exclusive jurisdiction still. That was preserved by clause 63 in the original waste disposal project agreement. So you can interpret clauses 15.2 and 13.2 in the deeds as merely confirming that the courts would retain background jurisdiction to intervene in arbitration, as would be the case under the Arbitration Act. So he sort of tied up that loose end quite neatly. Now, I think there are two comments on this judgment. The first one is that clearly the judge was confronted with ostensibly conflicting provisions and tried to make them work. Now, that is not an approach that is unique to PFI contracts, far from it. But I think it is a particularly apt approach, given the fact that because of the nature of these contracts, as we discussed, they are going to be more susceptible to potentially conflicting and incompatible provisions. Therefore, it's much more important to try and make the contracts work and give them some sensible commercial effect. I think the second point arising from this is that we've talked about the complexity of these agreements. Now, you're starting with a very complex agreement of 5,000 pages, and you're adding to it in 3 more deeds of variation, 3 more layers of complexity. So obviously you're adding complexities, and this makes it far more likely that you're going to encounter the sort of infelicities that Lord Justice Jackson talked about. It means it's very important indeed, if you are involved in drafting deeds of variation or supplemental agreements to project agreements, to get your drafting tight. So you're not actually creating opportunities for further ambiguities or further inconsistencies or infelicities, I suppose, that can arise. As was the case here, I think Surrey were probably quite surprised to find that they had to go back to arbitration rather than court proceedings, but that was a sensible interpretation of the project agreement by the judge, I think. And I think the judge in that case did rather well to make sense of them. Right, now back to Fiona. Thank you for Buckinghamshire and FCC Buckingham.
Thank you, Ted. Yes, another waste disposal contract. This time, the dispute concerned third-party income, often a source of great tension between the authority and Project Co and its affiliates. Who is entitled to the third-party income which Project Co and its affiliates obtain as a result of having access to a facility which is actually being paid for by the authority. And indeed, what we see happen all the time is that Project Co, as the SPV created for the specific PFI contract, effectively seeks to make a bit more on the side by entering into ever more complex contractual arrangements with its affiliated companies in an attempt to sidestep the provisions which it has agreed with the authority under the contract for the sharing of third-party income. And the main issue in Buckinghamshire concerns the latest attempt by an SPV to do just that. The main conditions of the contract, Ted, if you wouldn't mind just flicking over onto the next, thank you, the next screen here. The main provisions of the main agreement provided at clause 47.2 that the contractor shall be entitled to handle, process, treat and deal with third-party waste, provided that any income derived from such handling shall be dealt with in accordance with Schedule 15, Schedule 15 being the PayMec. Now, the important point about clause 47 for the purposes of the argument that the judge had to consider was that that clause was limited in its scope to the contractor. Other parts of the PFI contract you also used the terms subcontractor and affiliates. And the affiliates, and indeed the definition of subcontractor, included a company called FCC Waste Services Limited. What happened in this contract was that it was FCC Waste Services Limited that went out into the broader marketplace and entered into waste disposal contracts with other local authorities and indeed other industries, pursuant to which it received income. It then, having agreed to treat third-party waste, entered into contracts with the service contractor under the PFI contract, also another affiliate known as FCC Recycling. It agreed, or FCC Recycling charged less for the disposal and handling of waste than FCC Waste Services was being paid by the other authorities and industries who were disposing of waste. So essentially a significant chunk of profit or income sat with FCC Waste Services and did not make its way up the chain through to FCC Recycling and ultimately FCC Buckinghamshire. FCC Buckinghamshire argued that actually it was not required to include the income which FCC Waste Services made from agreeing to process third-party waste in the third-party calculations, which we'll come to look at in a moment. And it did so on the basis, firstly, that clause 47.2, as we can see, is limited to the contractor's entitlement to handle, and the argument being that any income must therefore be income which the contractor has derived. And also FCC relied upon certain of the words in Schedule 15 of the PayMec. Under the PayMec, obviously, FCC, as is normal, was entitled to a monthly unitary charge from the authority, and the parties agreed that that charge was to be calculated by a formula which included for a deduction to be made in relation to the third-party income share to which the authority was entitled. That third-party income share was to be calculated to include, as we can see there by paragraph 11, third-party waste excess TPI. And third-party waste excess TPI was defined by paragraph 11.4 as third-party income derived from gate fee revenue. And again, FCC relied upon the term gate fee revenue as being revenue that essentially fell to the contractor as opposed to revenue sitting with FCC Waste Services. The judge was having none of that. She preferred the approach adopted by the authority. And in particular, she said that it was important to have regard to the definition of third-party income set out in Appendix A. And third-party income as defined in Appendix A, as we can see set out at the top of that slide there, included income from third parties obtained by the operating contractor and or any affiliate, which for these purposes definitely included FCC Waste Services. So what one sees there is, again, that tension that Ted's just been describing in terms of the arbitration clauses. There's a tension there between the way in which the main agreement deals with third-party income and the way in which third-party income is defined by the definitional section as a whole. And really what the judge is doing there is saying, in this case, it's important essentially to look at the overall purpose of the agreement and what the parties were really striving to do. And she said that really to do that, one should base oneself in the definitions contained in Appendix A, as opposed to the more specific provisions of the PAMEC and indeed Clause 47.2. Now, that might come as a surprise to some of us who might think that the express terms of certainly the main contract might be thought to override a definitional term in an appendix. But standing back and looking at the way in which these income sharing schemes typically operate under the PFI contracts, perhaps it's not surprising that what happens here is a judgment which favours essentially common sense rather than allowing an SPV to take the benefit of the way in which those engaged in PFI contracts or providing services under PFI contracts choose to structure themselves corporately for the purposes of trying to maximise their own profit at the expense of that which they have agreed to be provided to the authority. So in a sense, a judgment which favours common sense, I think, rather than perhaps a strict legal analysis of the way in which one might have thought that those terms would work themselves through. Just before we finish on Buckinghamshire, I think one other final and important point about that case is that Buckinghamshire had asked also for wholesale disclosure of not just FCC Buckinghamshire's, but also all of its affiliates' documents arising out of third-party waste income. Which caused FCC some form of consternation because it thought it was going to have to disclose all sorts of commercially sensitive information to Buckinghamshire. There were two clauses in this contract which provided for the disclosure of documents. One which was very limited to documents which recorded costs incurred by FCC in building and operating the project. The judge said that clause offered the council no opportunity to get hold of the documents itself because it was limited to costs but not income. But the much more broadly worded clause which allowed any auditor of the authority access to documents that it might reasonably require to discharge its audit functions did allow the disclosure of some, but not all, of the documents that the council was asking from the SPV and its affiliates. So that's it seems to me is also quite an important point just from a practical perspective. Those of you who are involved in operating SPVs and the affiliate companies that go to provide their services need to be aware that some of these broad clauses in the contract which entitle an authority to documents can be used to acquire disclosure which is broader than at first sight you might think that you are obliged to give. So thank you, Ted.
Thank you, Fiona. Right, on summary, I think we agreed that I would do common themes in dealing with infelicities and Fiona will do the other two, so I'll do them together. Common themes, probably not a lot of precise common themes. I think the common theme is that the contracts to be looked at all contained inconsistencies, ambiguities that were unresolvable by the parties and needed to get a third party to decide them, which is often the case. I think the theme that we've considered is one of infelicities, and clearly there's quite a lot of them in PFI contracts, let's say. I think in terms of dealing with infelicities, then the best approach is to follow Lord Justice Jackson's guidance and adopt a reasonable approach, and you know, nothing too extreme. That's not going to succeed. I think the example was, if your lawyer comes and tells you that you will still get paid your services payment even though the hospital has been destroyed by a meteorite, I think that is where you say, well, hang on a minute, I'm not so sure about that, and don't base your profit forecast on the assumption that the money will still keep coming through once the hospital was reached to a smoking ruin. So I think that's the sort of common themes I would say, yes.
Thanks, Ted. I think in terms of what I've been talking about, Essex County Council, which is an extremely lengthy judgment, but is actually a really fascinating read for those of you who litigate or arbitrate PFI contracts, seems to me to be authority when one looks at the actual background and detail of the dispute, for the fact that actually relying on a good faith obligation or breach thereof will not help you at all if the reason that you've got yourself into the mess that you are in is as a result of your own default or deficiency. Similarly, that case, I think, also offers many important lessons about how to prepare effectively for PFI contracts litigation. The start of that judgment effectively contains an excoriating account of the behaviour of UBB, which, if you were a shareholder of any of those who actually invested in UBB, would not have been a pleasant read at all. As the judge remarked, it was somewhat ironic that UBB accused the authority of acting in breach of its good faith obligations when sitting in its own internal disclosure were documents which indicated that UBB was well aware that it is significantly under-designed this project and had not a hope in hell of meeting the performance requirements or passing the acceptance testing a good year before it let on to the authority that there were problems. So preparing effectively for PFI contracts litigation, actually no different to preparing effectively from any form of litigation, which is know the documents that sit in your own inboxes before starting to throw mud at the other party. Thank you, Ted.
Thank you, Fiona. Can I just add two more points on that preparation? I think the important thing is to think about the fact that PFI contracts are not bilateral. They're part of an interlocking arrangement of contracts, as mentioned at the start, the project agreements at the middle, and the FM contract, construction contract down below, and the authority project agreement higher up. So primarily for project co, but also for the other parties, if you're thinking about disputes, then you have to think about the bigger picture, because it's not just going to be against project co on its own. Project co is going to have to think about what the authority wants, and there are, most PFI contracts include provisions for related disputes, which means there can be consolidation of disputes to ensure that the same decision is made on the lower tier contract and on the project agreement. And secondly, again, advice that could be given to anyone involved in litigation, it's a good idea to try and settle if you can, because if you have a dispute halfway through your services period, that is likely to make people not like each other, like to polarize the parties, but you still got to get on with each other for the next 10, 15 years. It's sort of like a couple who divorce but have to share the same house for another decade. So if you don't want to deal with that sort of tension and toxicity, my advice is to settle. Thank you.
Thank you. Super. Thank you, Ted and Fiona. Thank you very much for dealing with those 4 cases so clearly, particularly when the common theme seems to be complexity and infelicity. I think we can all see that, whether it's the disputes, the contracts, in the area of law, and as I learned, the detailed maths that you need to grapple with if you want to interpret your definitions, thanks to the formula in the Serco case. So I think we've got time for maybe 2 or 3 questions. I'm going to start with, we've had a couple of questions around the duty of good faith. So if we could start with that. I'm going to combine some of them together. Can it be assumed that when interpreting PFI contracts, judges will automatically imply a duty of good faith? And has the implied duty of good faith reached a high watermark? I don't know, Fiona, possibly?
Shall I take that one, Ted?
Yeah, sure. Thank you.
I think we can now assume that PFI contracts will be contracts which are subject to an implied duty of good faith. It's also important to note that many PFI contracts are also subject to an express duty of good faith as well. And indeed, some of the clauses in the Essex County Council case themselves required the authority to use good faith before exercising a right available to it. So I think going forward, yes, one has to assume that good faith will play a role in the interpretation of contracts and the deciding disputes between the protagonists. Has good faith reached its high watermark? Essex isn't really a particularly good test as to whether we're at the high watermark of good faith. And the reason for that is that the facts in the Essex case were almost so extreme that frankly, it was a bit of an ask to suggest that anyone was going to find that the authority in that case had been guilty of a failure to comply with its good faith obligations. I suspect that going forward, circumstances will arise in which it's not so clear cut. So if we think about in UBB, where it was obvious that the designer had misdesigned the project, and internally that was recognised within the designer's own organisation. In many cases, that won't be obvious and it won't be clear cut. And indeed, actually, because of the cutting edge nature of this technology, in some cases, the reason why something doesn't meet the acceptance criteria won't actually be determined until the trial judge reaches his or her decision on it. And in those circumstances, one might see how the obligation to exercise good faith in dealings with one's contractual counterparty might lead to a different outcome than the one that we saw in Essex. So really, I think probably watch this space, Stacey.
Thank you, Fiona. That's brilliant. I'm going to move on to this, the second question. This question actually came in prior, an advanced question, which is fantastic. Do the speakers have a view on whether unavailability deductions, including deductions for unavailable but unused areas, can amount to a penalty?
I'll take that one if I may.
Thank you.
Thank you, Stacey. An interesting point. The very quick answer is probably not. The provisions for unavailability and unavailable used, which lead to deductions, will normally be negotiated between parties at length, both parties being represented by phalanxes of lawyers. And it's not as if they represent any inequality of bargaining power. Also, they're fairly standard, and I'm not aware that anyone has challenged them. Unavailability mechanisms on the basis of penalty. However, I think that there's always a sort of exception, and I think that you might end up falling back on basic principles that if the unavailability mechanism imposes a penalty which is disproportionate, then in that case you might have an argument. I mean, I think of an example: if you have a 1,000-bed hospital and there's a cleaner storage room on the second floor, and that is unavailable because the lights are broken. If that unavailability gives you deductions, worth £1 million, which is like 1 month of your service payment, then that's clearly vastly disproportionate to the loss of amenity suffered by the trust or the hospital authority. So I think that would probably be susceptible to an argument that it was a penalty. However, as we know, almost all unavailability provisions are far more modest than that. they only start to ratchet up if the room or ward or whatever is left unavailable for a long time, and you might say that's fairly reasonable. The point about unavailability is that the hospital or the school or the prison wants use of this room, doesn't have use of this room or space because of failings by the PFI contractor, so therefore there should be some form of compensation. I think the second possible example of disproportionality would be, say, if one of the spaces that was unavailable served no purpose whatsoever, and I think an obvious example would be the hospital grounds, let's say, if a penalty was exacted because the hospital grounds weren't available. I can't quite think of a situation which they wouldn't be, but if that was the case, then you might say, getting back to basic principles on penalty clauses, we are being, as a project company might say, we are being punished here financially and in respect of something for which the hospital trust has not suffered a loss at all. They don't have their grounds available, the grounds aren't used for anything, and therefore that is disproportionate, and therefore that could be a penalty. But again, grounds do have amenity. Patients like walking through them. It's good for mental health to get out in the fresh air, so I'm not sure that would succeed either. So I think generally speaking, the answer is probably not. Unavailability provisions are not going to be a penalty clause, but there may be some exceptions in interesting and different circumstances.
Super. Thank you, Ted. That's brilliant. And let's squeeze in one last question. It's a bit of predictions. It is the new year, 2022, and crystal ball gazing. Is the frequency of PFI court judgments likely to increase?
If I may,
thank you.
I think yes, on the grounds that the number of PFI disputes is likely to increase. And the reason for that is that the more disputes we have, the more are going to filter through to the courts, I imagine. And the reason why we're going to have more disputes is because for a lot of PFI projects, we are approaching the time of handback when the asset is returned to the local authority. And my own view on that is that the handback provisions are even more susceptible to argument than the points we talked about thus far. Many of them were drafted in the 1990s, and maybe the lawyers working on them didn't worry too much about them because it was 30 years off. But I think a lot of the ones I've seen, handback provisions are just sparse of any useful detail, and on that basis, there's going to be a lot more arguments, particularly as the authorities will realise that this is their last chance to get the hospital or school or prison in top condition, and the project companies will realise that they'd like to get away with their money, frankly. So there's a clear tension there, and frankly, a lot of money at stake, I imagine. So I think yes.
I also think yes, perhaps for a slightly different reason to Ted. I think, especially in relation to those PFIs of a slightly shorter duration, we're probably about to enter into a new phase in the economic cycle. Inflation's about to go through the roof. Some of those predictions which sit in the base case financial model, which really is at the engine room of all of the PFI disputes that Ted and I see, may well about to have a hole blown through them. And as and when SPVs start losing money, then one will start to see the disputes trickling through.
Thank you both. Thank you for taking those on. And thank you very much for your time today and giving us such a clear explanation of those cases and our audience's questions. So it just leaves for me to, in the usual way, market our next upcoming webinar. In 2 weeks' time, we're going to be discussing BIM and digital technologies, the latest legal and contractual developments. You'll have myself joined by Jeremy Glover and as well May Winfield of Borough Happold, who is an expert in BIM and all things digital, and we'll be focusing on a number of aspects, not least of which the newly released information protocol for the ISO 19650 Part 3. So I do hope you can join us in 2 weeks' time for that session, and you can register at the link down there. But thank you very much, everyone, for joining today, and it's great to see you back in 2022. And I hope you are safe and well where you are, and we shall see you again soon. Thank you very much for joining.
Thank you.